The LegalFuel Speaker Series, Better Lawyer, Better You. LegalFuel is the practice resource center of the Florida Bar and a benefit to Florida Bar members. This ongoing speaker series will feature seasoned leaders from Florida's legal community who represent a wide spectrum of legal expertise and practice. With a focus on the fundamentals of today's legal practice, topics include finance, technology, human resources, marketing, client development, and day-to-day operations of your law firm. The LegalFuel Speaker Series is brought to you by Florida Lawyers Mutual Insurance Company. Florida Lawyers Mutual, defending the reputations of Florida attorneys since 1989. Go to flmic.com to learn more about the company created by lawyers for lawyers. We are now proud to present you the following.
Hi, I'm Chris Searcy. I am a trial lawyer, and I am the CEO and chairman of the board of Searcy, Denny, Scarola, Barnhart, and Shipley. We have a statewide practice with our main office in West Palm Beach, Florida. And the Florida Bar was kind enough to ask me to talk a little bit about how to take your practice to the next level. I believe that they wanted me to orient this towards lawyers that are starting out. And I believe I was a particularly good choice because I never had an interest in business or building a firm or any of the things that have to do with what you would think of as taking your practice to the next level. I got into the law because I wanted to be a trial lawyer. I wanted to be able to go into a courtroom and make a difference. And so I think if I now have a firm of 31 lawyers and about 150 people that has been successful and I think well respected, if I can do it, then you can do it. And so I do believe that I might be a good person to talk about this. And I'd like to just sort of relate my story because I believe maybe there will be parts of it that will fit you and maybe enable you to do a better job, or move more quickly, and get to where you're going with your practice. I think one of the first most important elements in the practice of law is to find the area of law that you really have a passion for, that you are interested in. Because whatever you enjoy most, if you're a golfer, if you like playing golf, if you had to do it about 12, 13 hours a day, 5 or 6 days a week, it would start seeming like work to you. If you start off doing something that you don't like much in the first place, it's not going to get better. So I do think you want to find the area of law that you really love, that you have a passion for, and then that will sustain you and give you the energy to do a great job. Secondly, I think it is very important to have good mentors. And how do you get good mentors? Some lawyers have the good fortune of starting off with a very good firm with a lot of role models that they can talk to and listen to and watch and learn a lot of good practices from. Some lawyers start out hanging a shingle. There are a lot of different levels, but I had the good fortune of starting with a good firm down in Miami. It was back then called Freites, Floyd, Pearson, Stewart, Proenza, Richmond, Weil, and Greer. And most of those folks are no longer living or retired, but I worked most directly with Larry Stewart and Morris Proenza, both very good lawyers, and I learned a lot from them. I had the good fortune of having a father who was a trial lawyer up in Jacksonville, who I probably learned more from than anybody. And shortly after beginning practice in Miami, I was hired away by a gentleman up in West Palm Beach by the name of Bob Montgomery, and went to a firm which at the time had 6 offices in different cities in Florida, doing mainly insurance defense work. And so I got to see what a bigger practice was like with about 55 or 60 lawyers in various cities. One of the things that I noticed from that is that firms tend to work better if they're all under the same roof, even if you're going to have a statewide practice. And so as I began to go from the employee level to the management level, that was always sort of one of my preferences, is to be able to keep things under the same roof if we could. But so how else can you get mentors? You can find lawyers in the community that are glad to talk with you, whether you give them a call on the phone, you ask them to have a cup of coffee, you see them in the hallway of the courthouse, and you've got a particular issue and say, could I get you to help me on this? I'm not sure what's the best thing to do. So I think once we have decided this is the area of law practice that excites me, that I'm passionate about, that I want to do, we want to try to be just as good at it as we can be. And how do you go about that? I think preparation is the great equalizer. I started out trying cases. I'm a kid out of law school, and I'm going up against people that have been doing it for 25 years. And how do you deal with that? I can remember the first case I tried down in Miami, and I'm sitting there in court getting ready to start, and I was representing a 13-year-old young lady who had been injured in an auto accident when she was 8, Kathy Dolan and her mom. And we're getting ready to start, and I see them sitting there just as confident and proud as they can be. And I remember thinking to myself, I said, good grief, they think they got a real lawyer representing them. But then I decided I was a real lawyer. I'd prepared very hard for that case. I was ready to go, and I tried the case. I left a legal secretary on the jury, and I had a real difficult time with whether I wanted to leave or not, and decided to do it. I tried the case. It was an angulated coccyx from a rear end accident, and I did a per diem argument about how if this young lady could, every time she was suffering that pain, could take a quarter and put it into a slot and be rid of the pain for 30 minutes, don't you know she'd do everything she could to keep a stack of quarters by her always, and multiplied it out by the hour, the day, the year, the month. Anyway, to make a long story short, she was young, had a long life expectancy, came out to $876,000, which is what I requested. We ended up getting a verdict from the jury, and it was $36,000. I was delighted. We had offered to settle for 10. We got $36,000. We go 10 days later for the motion for new trial. The judge says, did any of you talk to the jury? And we said, no. He said, well, I did. I said, you know why you got $36,000? I said, no, sir. He said, well, 5 of the jurors wanted to give you $876,000. That legal secretary you left on the jury knew it wasn't worth that much. So I must have looked crestfallen. He said, but don't worry, son. If it was $876,000, I would have granted the motion for new trial, but I'm denying it. You've got your judgment. So I wasn't afraid to go in there to do it. If I was going to be a trial lawyer, I had to try cases, and I tried them. The very next case I had was in federal court. I'm getting ready to go to trial. You want to be in control of every little thing, and you can't. So I get up about 4 in the morning and drive into the office so I won't catch a train or a wreck on the road or get delayed. And I'm in there working. It's about 6 o'clock, and there was a coffee shop catty-cornered to the Concord building and the Dade County Courthouse that opened at 6. I go over to get an English muffin and a cup of coffee. I can remember this day. I take a bite of that English muffin and I go to swallow it, and I was so nervous, my mouth and throat were so dry it got stuck. and I'm sitting there coughing on the counter. I'm worried maybe throw up, so I go running outside. I finally clear it and get the bite of English muffin out, and there I am looking over the slums of Miami with the sun just coming up through the haze, tears coming down my eyes from almost choking. Say to myself, is this really what I want to do for a living? And then I think for a minute and think, it beats being bored. And I settled down, went in, had my English muffin and coffee, went back, tried the case, won the case. But whatever line of work we go into, wherever our passion is and what we're going to do, we can't be afraid to take the shot. Michael Jordan is a great basketball player. He's not going to make every shot. If he was afraid to miss, he could never take a shot. And we can't be afraid to try the case or do whatever is the cutting edge in the specialty that we desire. So one of the best ways to make a name for yourself if you're in litigation as I am is to go in and try cases and get good results. You can settle cases this day and time. If you settle them for any significant amount, you're usually keeping it confidential. The best way to get everybody to know you as a trial lawyer is to go in and try cases. Whatever the cutting edge is in the area of specialty you choose, you need to be willing to take the risks and go and do the important stuff. That's so important to developing an image. The coverage you get when you're doing something public, for instance, trying a case, is better than any of the paid media that you can get, in my humble opinion. But I believe the most essential ingredient to building a name and building a practice is satisfied clients. There is no marketing, there is no advertising, in my opinion, like a satisfied client. If your client knows that you have taken the time to listen to them, you've given your best for them, they're gonna, for the rest of their life, they're gonna think very highly of you, and whenever somebody they know needs a lawyer that's in your specialty, they're gonna be saying, you need to go to him. He will really take care of you. And that is, I think, very essential to building a name and a practice. Now, something I did, and this might be something that you want to consider, and I didn't do it to build a practice or develop cases or anything, but I went to law school in Florida, at Stetson, and I had a bunch of good friends at Stetson. All of a sudden we graduate, we go to practice in our different areas, and I don't ever see them anymore. And we had a statewide practice, and I was always going to different places to try cases, take depositions. I would look up and see which of my old classmates were in that town, and I'd go and just pop in on them, no appointment or anything, say, I'm Chris Searcy, here to see my old pal so-and-so. Go in and talk with them, ask about them, tell me about your practice, how you doing, how do you like living here, this and that. Most of the times I did that, before I walked out of the door, they had referred me a couple of cases. That wasn't why I did it. That's not what I expected, but it just happened. And after it happened enough times, consistently enough, I thought, well, gee, this must be a good way of developing your practice and your name, because whenever I get to go see an old pal that's really fun for me, they end up referring me cases, either from them or someone else in their firm. And so I commend that to many of you. That might be a good thing for you to consider and to try. In building a name and in building a practice, it's not all marketing, it's not all advertising. A lot of it is becoming good at the area of law that is your passion. And I think if you're passionate about it and love it, then you're apt to become very good at it. But when you start out, as I was just mentioning in that example about one of my first cases, there are going to be people with more experience than yourself. I've been doing a lot longer than you. And that doesn't matter. If you out-prepare them, you can do a better job than they do. Preparation is the great equalizer. And if you get well prepared, you can be practicing for 1 year and take on somebody that's been practicing 30 years and outdo them. Just like the 6-gun was the great equalizer in the Old West, preparation is the great equalizer in the practice of law, particularly in litigation. And when I started out, I had that drummed into me by a great trial lawyer of that day who was getting towards the end of his career. But we would have a Friday lunch every day catered into the library where we would talk about cases. And Bill Freites, when someone would ask about a question and how are we going to address this, he'd say, all right, what does the U.S. and state Constitution say about it? What do the U.S. and Florida statutes say about it? What do the rules of procedure say about it? Back then we didn't have an evidence code, so he wouldn't ask that, but if we'd had one, he would have. What does the case law say about it? Are there any rules or regulations to be considered? He wanted you to be prepared. And then when you take all that into account, you need to be prepared on the facts. And his saying was, turn every page. If you're getting ready to go to trial, turn every page. Don't let there be any kind of fact you can be surprised with or that you don't know about. And once you've done that and you know the law, you know the facts, the next step is you want to tell a story. You want to tell a story about what happened so that anybody listening to that will feel a need to correct the injustice that you were addressing. And that the way to correct that injustice is going to be by entering the verdict that you are promoting them to enter. And if you can do that with facts that you know are coming into evidence under the law that you know the court's going to instruct the jury on, you're going to win that case. Or by the time you finish opening statement and you give that story and the trier of fact sees it through your eyes, it is yours to lose. And unless you mess up somewhere else along the line, you're going to win that case. So preparation is the great equalizer. Preparation will enable a young lawyer to take on a much more experienced and skilled adversary and win nevertheless. A very important ingredient in a successful law practice and building a successful law practice is listening to our client. That's like watching the ball until the strings hit it when you're playing tennis. It's very basic. It's such an important fundamental, and if you don't think about it and pay attention to it, you get into habits and quit doing it. And it's something we always want to remind ourselves to do. I, every day, talk to myself and talk to other lawyers in my firm. I tell them, I say, Chris, listen to your client. He or she is trying to tell you how to win your case. And I'm here to tell you from 46 years of experience, when I really listen to my client, and that's hard for me sometimes because, like all of you, I've got a million things going on. When I really stop and listen to my client, every hour I spend really listening to my client saves me at least 25 hours of wheel spinning in that case. It is so important. So that combines with the power of belief. And I believe that one of the strongest forces in the world is the power of belief. And for us to be good at what we do, we have to believe in ourselves. There's a difference between being cocky or conceited or what's the term that's always used? The guy that looked at himself all the time in the mirror. That's not believing in yourself. Believing in yourself is saying, I can do this. There's nobody that can do this better than myself. I can do it. So we need to believe in ourselves. We need to listen to our clients. Listen to them carefully. They're trying to tell us how to win our case if we're litigating. They're trying to tell you how to take care of their business if that's it. They're trying to tell you how to write their best will if that's what you're representing them for. We need to really listen to our clients. And we need to believe in our client. We need to believe in our client unless and until our client proves that we can't believe in them. I can tell you there are a lot of times where I think maybe I was getting a little bit mentally lazy, where I had this case, I thought it was a good case, but I talked to the client and I see what's going on and it seems like they're doing things that hurt their case. And I find myself trying to get them to be more like the clients in the case that I tried and got such a good result on. And that's not what we need to do. We need to really listen to them and make the case fit their facts. It never works right if you try to get them to fit the mold of another case. I guess the best example would be you don't want to take a size 12 foot and try to shove it into a size 8 shoe just because the size 8 shoe in the last case worked really well. You want to say this is a size 12 foot. I need to build a size 12 shoe to fit it. And I think maybe the best example I could get is I had a wrongful death case. It was the death of a husband. And the reaction to the wife over the death of her husband caused a lot of erratic behavior on her part. High risk behavior, sleeping with just about everybody in town, getting in trouble, getting DUI, and I had her go to a psychiatrist. I said, go consult with this psychiatrist. We need some help. You need some help. I need some help. She did. There's a gentleman in town, McKinley, Cheshire. And I can remember going in to meet with Dr. Cheshire and saying, Dr. Cheshire, can't you do something? She's ruining her case. She has a good case, but she's going to keep the jury from believing in her. And I can still remember, he said, Chris, I'm going to tell you something, and I want you always to remember this. He said, the actions of a fish on a hook seem bizarre and without meaning to the rest of the fish in the school. But each action has precise and exquisite meaning to the fish on the hook. And I did pay attention to him, and I did listen to him, and I understood what he was telling me. And I understood that what the erratic behavior, the self-destructive behavior that this young lady was going through was a reaction to her husband's death. It was the way she was manifesting her damages, and instead of trying to sugarcoat it or hide it or disguise it, I made it a badge of honor in the case and showed how terribly it had changed her life. And the case was very successful. We got an excellent verdict because I listened to my client. I believed my client ultimately. I had to do some investigating to get to the point where, yes, I did believe her, and yes, it was real. And then when I presented the truth worked tremendously. The old saying, the truth will set you free, there's a lot of truth to that. How are we perceived by the public? The public are our colleagues, other lawyers, our judges, the bench, the bar, the community, everybody. How are we perceived? Nobody is smart enough to fool everybody all the time, we're ultimately going to get perceived for who we are. I think to be a lawyer, a good lawyer, to build a good reputation, we need to have integrity. Integrity, integrity. Our word needs to be our bond. If we give our word, that's as good as signing it, making 100 copies of it and dropping it out over town. If we don't give our word lightly, if we give our word, we don't ever go back on it. Integrity. Stick to your word. I settled cases on a word and a handshake for tens of millions of dollars. I couldn't do that when I first started practicing. If you make your word your bond, if you practice integrity long enough, everybody ends up comparing notes. They know if you give your word on something, that's as good as anything that they could have in writing or in the bank, and it enables you to do things that you wouldn't otherwise be able to do. So integrity is so important. And once you have that, how do you come across the outside world? I figured out back when I started practicing law, where advertising was not allowed in any way, the best way, the way the public perceived us was how we dressed, the house we lived in, the car we drove, the office we worked in, how it looked. And it was to our best interest to look successful, live successfully, drive successfully, dress successfully, work successfully. That's part of our image. And I think believing in ourselves, where when we speak, we're speaking with confidence, is so very important. The tone of voice that we use with anybody is just as much a part of the message as the literal wording that we used. And I remember my dad, who was a lawyer, just always liked to experiment. And I can remember one time one of my little brothers was walking up the back steps onto the landing, and my dad looked over at him and said, "Did you hesitate on the landing?" A very accusatory tone. He said, "No, Daddy, no, I promise I didn't." And of course, there he was standing on the landing. But it didn't matter what the words were, it was the tone that was used. It was accusing him of something bad, and he hadn't done anything bad. And I've learned a lot of things unconventionally from my dad in that way. But tone of voice is so important. That's probably 60 or 70% of what the listener takes in. So it's important for us to be able to speak with confidence. Now that we have advertising, and I can remember we were one of the later or last firms to get into doing any type of media, and I guess it was in sort of the late 80s, and we always got a lot of cases referred to us by other firms because of our work and the fact that I think we did have integrity. We worked with a lot of firms. We got all our business through referrals. And I noticed that those were dropping off, and I would talk to referral lawyers, and they said, well, we're not getting as many cases because they're going to advertising lawyers. And I realized then, I said, you know, we're either going to advertise in some way, or we're going to work for people who do. And so what we did is we called it an image building campaign, where we tried to do things that would not only help promote our image to the community, but help to promote a positive image for the bar in general, to do spots that would bring goodwill to us and goodwill to the justice system and to the bar. And it was more expensive to do it that way. It was probably a little bit slower doing it that way, but it seemed to work well for us, and we still make an attempt to do that. But I do believe that media Websites, things that I'm not as skilled at as my lawyers under 30 are here to stay. They have so much to do with which lawyers are getting what business that we need to pay a great deal of attention to that. There are a lot of good consultants. There are a lot of people that know a great deal more than I do about that, so I'm not going to try to give advice on that part of it. But other than to say it is very important, there are a lot of very inexpensive ways to market now with websites and social media and so forth. I think it is very important for us as we begin to succeed with our practice to give back. To whom much is given, much is expected. It's important for us to give back, and we can give back in so many ways. Pro bono work. We can help people that need help even when they can't afford a lawyer. You never know what will happen to those people. They may become an excellent source of business for you. That's not why you would do it, but to give back. We're going to live in a community, and we're fools if we don't help that community be a good place to live. So there's so many ways we can be of great help to our community, both locally and statewide, and we should take advantage of that. If we've got children in school, we ought to help in that school, be part of the leadership of that school, be part of the fundraising of that school. Same thing for the local bar association, for the state bar association. If we're in a specialty, in my instance, litigation, now primarily from the plaintiff's side, the plaintiff's trial lawyer associations, the other trial lawyer associations, both plaintiff and defense and criminal, BOTA and the International Academy of Trial Lawyers and so forth, to be part of it. Give back, help, share your knowledge with other lawyers. You're helping yourself have a better world to live in. I think it's very important. We need to do it for the right reasons, not so that we can market or get cases, but so that we can help. And I think when we're doing it for those reasons and we're trying our best to make a better community and help, then the good, the business, the cases, the reputation all follow suit from those good efforts. And everybody's always very willing to have our help, and we should take advantage of that. There's an old adage that you don't want to be unevenly yoked, and there's a great deal to that. If you're going to be working in a law firm and you have any control over it, you want to be working with the best people you can work with. There's some firms, it seems, that hire sort of people that they don't think are ever going to be a partner in the firm, that are bag carriers or whatever. I don't believe in that at all. Every lawyer we hire, we expect that lawyer to become a shareholder and partner in the firm, to be able to try any case we've got. That's what we're looking when we hire someone. With regard to our staff, I would rather pay significantly more money and get the best legal assistant or secretary or paralegal there is than to save some money and end up with less superior talent, because they're part of everything we do. The better they are, the better we function, the better we succeed, the happier our clients are, and we can't be afraid to pay what we need to pay to get excellent staff. I think that's so important. With regard to firm mentality or tradition, what works best there, I don't know. I just noticed that when I started out, there are a lot of very famous plaintiff personal injury firms in Florida. And it seemed like all of them, when the top lawyer retired or died or for whatever reason, was no longer there. They just imploded. They were no longer. People would go out sometimes and start other firms, but the firm was gone. And so one of the things that I did when my firm was growing, because we kept getting more business, we kept needing more good lawyers, is I thought to myself, it'd be sort of nice if everything doesn't just go to hell after I die. And so what needs to be done? One of the things I realized is that you need to compensate people in accordance with their productivity. And that just doesn't just go for the young lawyers, but for the older ones and the senior lawyers as well. And when it's time for us as senior lawyers to want to cut back in our efforts and our work, then we need to be willing to cut back correspondingly in the amount of our compensation. And if we approach it with that in mind, there's no reason that we can't begin to cut back, work hard when we're working, but maybe fewer hours, but we've got to be willing to recognize that in the level of compensation. And as long as the leaders do that and they begin some succession planning and the good younger shareholders that can take leadership from them gradually, not all at once, there should be very smooth transitions into ongoing firms. We at one point had an issue and we had Chesterfield Smith and his firm, who many of you might know, representing us. And they told me the story of Chesterfield when they had this great big board meeting. And there was a lot of jockeying for position and uneasy feelings and unhappy feelings about who was going to be on the letterhead of the firm. They had about 16 or 17 people, and there were some who thought that was too many or not enough. There are others who were next in line who wanted to have their names on the door. And Chesterfield got up at a meeting and he said, the name is just too long. I think we ought to just call ourselves Holland and Knight. Well, the name of the firm at that point was Holland, Knight, Smith, so forth, so forth, so forth, so forth. He took himself off the name of the firm, put everybody else in that firm in a position where they couldn't complain about their name not being on the door if Chesterfield Smith's name was not on the door. It solved that problem. I think that law firm now has about 2,000 lawyers in it or something like that. So it obviously worked very well. And I think leadership takes a person that's going to put the interest of the overall firm, all of the people, ahead of his own individual interests. And Chesterfield Smith was certainly one of my mentors in doing that. I think in succeeding in a practice, succeeding with our chosen profession, succeeding in an area that we're passionate about, we need to believe that we can make a difference. I think that we will keep growing and keep improving if we believe that we can make a difference. And the best example I can give of that is when I came up to West Palm Beach with Bob Montgomery's firm. We were doing all insurance defense work. I found myself doing mostly medical malpractice defense. And in the course of about 6 years, I must have tried 30 or 35 jury trials, medical malpractice jury trials, which are long jury trials. And back then we had medical mediation, which was sort of like a non-jury trial with a judge, a doctor, and the lawyer. I must have had close to 100 of those, and I won them all. I thought that when it came to medical malpractice cases, I was the greatest thing since sliced bread. And then I got a plaintiff's case. It was a plaintiff's case I believe I should have won. I tried the case and lost it. And then 6 months or a year later, I had another plaintiff case. I said, well, that must have been, I don't know what happened, but I'm going to win this one. I tried that one and lost it. And I didn't say, oh, it's just a bad jury, oh, it's all these dumb people, oh, this or that. I said, if I was a good enough lawyer, I would have won those cases. And I stayed up nights for a long time, 6 months probably, thinking about if I was a good enough lawyer, what would I have done differently and that would have allowed me to win those cases. And after a lot of searching, I think I came upon why I had lost those cases. And it was because I presumed the trier of fact would understand things that they weren't going to understand. They had never been in an operating room. They had never made a decision of whether to continue working up a patient or going into surgery because that was a less dangerous option. They had never had to make any of these judgments of whether to give a patient Pitocin to stimulate their labor or whether they were getting overstimulated and needed to stop it. And it dawned on me, I need a teaching expert. If I want the trier of fact to be able to recognize the truth from the fiction, they need to understand, at least for this finite portion of medicine or products or whatever the subject matter was that the jury or trier of fact doesn't have practical knowledge with. And I don't think I've won every case since then for the past 30-something years, but I've won just about all of them because I figured out why I didn't win those. I didn't satisfy myself, oh, I got a bad jury, or oh, bad rice, things didn't work right. I said if I was smart enough, I could have won those cases, and I learned from it. And I think that is what we ought to do. I think we need to believe in ourselves. We need to believe as the lawyer we can make a difference, and when we fail to make that difference, figure out why, figure out how the next time we'll be able to succeed in making that difference. And I think that is so important. Something that was always important to me is if I found something that worked in my practice, whether it was trying cases, running the firm, I liked to share that with people that were interested. I liked to tell them, hey, this really worked, you ought to try it. I guess for one reason, my family didn't like to hear me talk about stuff that I did. I did it too much and it bored them. And it's fun to talk with people that are really interested. So I've done a lot of speaking for continuing legal education. When I go to seminars, I find myself standing outside the seminar room with a cup of coffee talking with other lawyers as much as I find myself in the room, and listening to their issues and their cases and trying to help them with what I've learned from my cases. You ought to try this. Oh, this worked real well in that type of case that I tried back over here. The good efforts, I think it's karma. When you're trying to give, when you're trying to do the right thing, when you're trying to help, it comes back to you. All of the people that I talk with, that I try to help, many times they end up associating me on that case or referring another similar case to me. Not because that's what I was trying to do, but because I really took an interest. I really tried to help. And then I think they saw from my really trying to help that I did know what I was doing. And they decided, why reinvent the wheel? Let's get him involved. So I think that's a good practice for many, many different reasons. As I mentioned to you, I never envisioned myself being the head of a big business enterprise like a big law firm. And the practice of law is the enmeshing of a profession with a business. I saw myself as the warrior, the trial lawyer, not as the ruler of a land or, in our instances, of a firm. But I find myself as the CEO and chairman of the board of Searcy Denny. And I think Searcy Denny is thriving, It's very successful. It seems to be well run, in spite of the fact that I never studied any of that. I had never taken an interest in any of it, and I just kept trying to do what was right and what made sense, and treating my firm like I would treat my family, which I did have some experience with. And I think in the long run, doing things the right way, doing it out of care and concern for others rather than selfish or reasons or wanting to grab or take unfair advantage, works so much better in the long run and allows us to keep growing, allows us to keep helping the community around us to thrive, and is so good in every way. So if I can do it, anybody that's listening to this video can do it. And I think if you approach it for the right reasons and you give it your best, that you will succeed. I've got a plaque on my desk, and it's a quote from Abraham Lincoln. And it doesn't really sound like something Abe would say, but it does sum things up well. It says, "Things will come to those who wait, but only the things left by those who hustle." So if you find something you're passionate about, that you love, and you're willing to hustle, you will be a great success. You'll take your practice to higher and higher and higher levels. And presuming that you had an interest in listening to this, then I had a good time talking with you about it.
LegalFuel connects Florida bar members with strategic tools designed to help you fuel your law practice with increased efficiencies and profitability. Whether you want to launch a new firm, better market your services, or strengthen your internal operations, LegalFuel provides attorneys with the resources you need to run your business smarter and more efficiently. Visit LegalFuel.com today to help manage your practice and fuel your business.